Imagine this scenario for a second. You've just been handed the reins to this massive infrastructure project. Let's say it's, I don't know, $1 billion desalination plant, or maybe like a huge combined cycle power generation facility.
Right, a real mega project.
Exactly. And, you're the project manager, you're feeling pretty good. The blueprints on your desk are flawless. The contractor's glossy brochure is, it's incredibly impressive, right? Filled with all these photos of global projects. So you sign on the dotted line.
As you do.
Yeah, as you do. But what if the company you actually signed that contract with is nothing more than like a hollow legal shell, just sitting in a filing cabinet somewhere with absolutely zero physical assets of its own?
It's a terrifying thought, honestly, especially for someone tasked with delivering a billion-dollar result.
Oh, yeah.
But the thing is, in the world of major construction, it's actually incredibly common. On paper, you think you have this titan of industry as a partner. But in reality, if things go south, you might be standing entirely alone.
And that is exactly what we're tackling today. Welcome to this deep dive. We're looking at this specifically for you, whether you're, a brand new project manager or maybe an ambitious professional stepping into the high-stakes world of major construction.
High stakes and high stress, for sure.
Definitely. Our mission today is to decode the critical role of something called a parent company guarantee, or a PCG. We're going to look at how this document acts as your primary safety net when you're managing the very real, very terrifying risks of contractor insolvency.
And we have a really fascinating stack of materials to guide us through this landscape today. We are working from a comprehensive legal guide on FIDIC Yellow Book contracts.
Which is pretty much the standard, right?
Exactly, the industry standard for these types of mega projects. And even better, we have a confidential, real-world EPC that stands for Engineering, Procurement, and Construction Parent Company Guarantee Template.
That's the good stuff.
It really is. It's essentially a masterclass in how to draft a document that actually protects your project when the worst happens.
Okay, let's unpack this, because before we can talk about how to use the safety net, the PCG, we really need to understand the high-wire act you're walking as a project manager. And that starts with understanding the FID Yellow Book contract itself.
Right.
For those managing these massive projects, the water treatment facilities, the industrial processing plants, the Yellow Book is the absolute gold standard. But it does something very specific and quite dramatic with risk, doesn't it?
It does. The key distinction we need to make here is between the Yellow Book and the more traditional Red Book approach.
Right. The Red Book?
Yeah. So in a traditional Red Book contract, the design risk largely sits with you, the employer, and your consulting engineer. You basically hand over a massive stack of detailed schematics to the contractor, and their only job is to just, build exactly what you drew.
So if the design is flawed, that's on you.
Exactly. That's your problem. But under the Yellow Book, which is specifically for plant and design build projects, that entire design responsibility is transferred entirely over to the contractor.
So they don't just build it, they design it, they execute it, they complete it. You just give them like the functional outcomes you want. You say, hey, I need this plant to output 100 megawatts of power, or I need this facility to purify 50 million gallons of water a day. How they get there is totally up to them.
Exactly. You give them the parameters, but the detailed engineering solution, the proprietary technology, the entire execution, that is entirely their problem.
Wow.
And that extreme concentration of responsibility means the financial health and the technical capability of that contractor is absolutely paramount.
Yeah.
If the plant fails its performance tests a year after it opens, it is entirely their liability. They have to fix it, rebuild it, or compensate you.
Which brings us to the core risk we teased at the very beginning. Because you would naturally think, great, I hired a massive global contracting group with $10 billion in annual revenue. I am totally safe.
Right. You feel secure.
But large contracting groups almost never bid on these mega projects using their main corporate entity, do they? They use what are called special purpose vehicles, or SPVs.
Right. And an SPV, by its very design, is a ring-fenced entity. If you actually look under the hood at the corporate structure of an SPV, it is, it's shocking how bare it is.
Oh, absolutely.
It often has minimal share capital, sometimes just like a few $1,000s. It has no actual trading history. Usually doesn't even have its own direct employees.
Wait, really? No employees?
Yeah, the engineers and managers are just seconded or loaned from the parent company for the duration of the project. And most importantly, it has zero independent financial standing apart from whatever intercompany support the parent decides to give it.
So signing a massive, complex engineering contract with an SPV is essentially like handing the keys of a brand new Ferrari to a teenager who doesn't have car insurance.
That is a very apt comparison.
Right. I mean, it looks totally fine while they're cruising down the street, but the second there's a crash, you realize there is absolutely nothing backing them up. Which makes me wonder, and I have to push back here a little bit,
Sure.
if an SPV is basically a ghost ship, a shell company, why do employers and project managers agree to work with them at all? Are we just willingly setting ourselves up for a catastrophic failure?
What's fascinating here is that the creation of SPVs is actually completely commercially rational from the parent group's perspective.
Yeah.
It's not some malicious scam.
Okay, so why do they do it?
Well, it simplifies their complex accounting, it makes forming joint ventures with other companies much easier, and fundamentally, it isolates project risks. A multinational corporation doesn't want one catastrophic desalination plant failure in one country to sink their entire global operation.
Right, that makes sense from their side.
Exactly. So it's a standard business practice. But you are absolutely right to be skeptical because while it protects them, it creates a massive information asymmetry for you.
Okay, explain that asymmetry a bit more for me.
Well, the contractor knows they're insulated. They know that if the project goes completely bankrupt, the parent company can just walk away and let the SPV collapse.
That could cut their losses.
Right. But you, the project manager, you're operating under this implicit dependency. You're relying on a massive parent group that you actually have absolutely no direct contractual relationship with.
And that implicit dependency is exactly what we have to mitigate. You can't just hope they do the right thing, Since SPVs are just a reality of the industry, you need a way to protect your project from that massive asymmetry.
Yeah.
Enter the parent company guarantee.
The ultimate safety net. A PCG is a direct, legally binding contractual commitment from the ultimate holding company to stand firmly behind the subsidiary's obligations.
So it forces them to be involved?
It essentially converts that implicit, trust us, we're a huge global company dependency into an express, undeniable legal obligation.
But wait, hold on. The FIDI Yellow Book already has built-in provisions for financial security, right? Like, there's usually a requirement for a standard performance bond from a bank. Why isn't a bank bond enough to protect the project?
It's a great question, and honestly, confusing a bank bond with a PCG is a very common and very dangerous trap for new project managers.
Really? How so?
Well, a performance bond is issued by a bank or a surety company. Crucially, it's usually capped at a fixed percentage of the total contract price, typically about 10%. And it's usually what we call on demand.
Meaning what exactly?
Meaning you don't necessarily have to prove a massive breach of contract in a court of law to get the money. You just submit a compliant demand letter to the bank and they pay out.
Okay, well, here's where it gets really interesting because 10% of the contract price sounds like a massive amount of money. If it's $1 billion project, that's $100 million.
It is a lot of money, yes.
But that 10% is utterly useless. If that billion-dollar facility completely fails its performance tests, can't produce clean water, and basically needs to be entirely rebuilt.
Exactly.
If we go back to our analogies, a performance bond is like a quick, on-demand security deposit from a renter. It covers, like, a hole in the drywall. But a PCG, that's demanding the renter's incredibly wealthy parents co-sign the entire 30-year mortgage.
I love that extension of the analogy because it perfectly illustrates the concept of coextensiveness.
Coextensiveness.
Right. Unlike a bank bond that hard stops at 10%, a well-drafted PCG is usually completely uncapped. It perfectly mirrors the contractor's liability.
Oh, wow.
So if the contractor is liable for a massive catastrophic design failure that costs hundreds of millions to fix, the parent company is on the hook for that exact same massive liability.
Yeah.
There is no 10% ceiling.
That's huge.
It is. But as with all things in contract law, there's a trade-off.
Okay, what's the catch?
The catch is a legal concept called secondary liability. A PCG is not an on-demand instrument like that bank bond.
Wait, hold on. So I can't just call up the parent company, say, hey, your subsidiary really messed up the concrete pour, and ask for a check.
No, exactly. You cannot just demand the money. Because the liability is secondary, you, the project manager, must first definitively establish that the contractor has actually failed to perform.
I have to prove it.
You have to prove the breach of contract, you have to prove and quantify your financial loss, and only then, after the subsidiary has failed to remedy the situation, can you call on the guarantor.
Man, that sounds like...
It means you might have to go through a lengthy dispute board process, or even formal arbitration before a single dime changes hands.
That sounds like it could take months or even years while my construction site is just sitting there gathering dust. That is a huge amount of friction.
It is a lot of friction, which is why the actual drafting of the PCG document is so critical. You want to minimize that friction as much as legally possible.
How do you do that?
If we look at the real-world template from our sources, the very first operative section is designed to tackle this. It's written in a way that essentially forces the parent company to pretend they are the primary contractor.
Oh, interesting.
Yeah, it states that the guarantor unconditionally and irrevocably guarantees performance, and it indemnifies the employer against all claims and losses as if the guarantor were the sole principal obligor.
As if the guarantor were the sole principal obligor. So that legal phrasing basically means the parent company can't hide behind the corporate veil of the SPV. They are stepping directly into the shoes of their subsidiary.
Precisely. It strips away the illusion of the SPV when things go wrong.
So we know what the PCG is, we know how it vastly differs from a quick bank bond, and we understand this friction of secondary liability. But let's get into the real-world application.
Let's do it.
How does this actually function when the absolute nightmare scenario happens? Like you're in the middle of construction, halfway through pouring the foundations, and suddenly a massive global supply chain crisis or ridiculous cost overruns push that SPV into formal insolvency. They are bankrupt.
This scenario right here is exactly why the PCG exists. This is the primary concern of any project manager.
Without the PCG, what happens?
Without a PCG, if that SPV formally files for bankruptcy, you are in a terrible position. The SPV's remaining assets become subject to the claims of absolutely all their creditors.
Oh, so everyone wants a piece.
Right. You, the employer, just become another unsecured creditor standing in line in a bankruptcy court, fighting over, like, office chairs and used laptops. You might recover pennies on the dollar for your massive damages if you recover anything at all.
That is bleak.
And meanwhile, you're left with a half-built industrial plant and a contract with a legal shell that legally no longer exists in a meaningful way.
But what if I have the PCG? Doesn't the guarantee just kind of evaporate if the underlying company dies? Because looking at our template, there's a specific provision, what I would call an anti-insolvency shield, that is practically flashing in neon lights.
Yes, Clause 3.2.
Right. It explicitly prevents the parent from using the subsidiary's bankruptcy as an excuse. It states that the liability of the guarantor shall absolutely not be discharged by the insolvency, liquidation, dissolution, or reorganization of the contractor.
It is a total lifesaver. That clause means the legal death or bankruptcy of the subsidiary does not terminate the parent's guarantee. You still have direct access to a solvent, fully capitalized entity, the parent company.
That is so powerful.
And the brilliant drafting in this template goes even further than just keeping them on the hook.
You're talking about the non-compete provision, right? Clause 7.1, where the guarantor agrees not to compete with the employer.
Exactly. Think about the mechanics of a bankruptcy. The parent company probably loaned the SPV a bunch of money to get started, right?
Sure, yeah.
So when the SPV goes bankrupt, the parent company is technically a creditor too. This brilliant drafting essentially says that the parent company cannot compete with you, the project manager, to claim whatever remaining cash or assets the bankrupt subsidiary still has.
Wow.
If the parent tries to swoop in and recover money from their own subsidiary before your project is made 100% whole, they are legally required to hold those recovered funds in trust specifically for you.
That is incredibly aggressive, and I love it. But wait, let me play devil's advocate here for a second, because we talked about how hard lawyers will fight due to secondary liability.
Oh, they will fight.
If I am the parent company and my subsidiary is going bankrupt, my legal team is going to go into absolute overdrive looking for loopholes to get out of this massive, uncapped guarantee. What if, as the project manager, I change the design of the plant halfway through the build? Or what if I generously gave the contractor a 6-month extension of time because of bad weather? Wouldn't the parent company's lawyers just jump on that and argue, hey, you fundamentally changed the underlying contract that we guaranteed, so our guarantee is now completely voided?
If we connect this to the bigger picture, you've just highlighted exactly why guarantee law is so incredibly complex and why using some generic standard template you found online is a recipe for disaster.
Right.
Under normal, common law principles, which are often referred to as guarantee defenses, varying the underlying contract without the guarantor's explicit permission absolutely does discharge the guarantor. They can walk away.
Just like that.
Just like that. But the draftsmen of our confidential template knew that.
Ah, so they explicitly closed the loophole. Let's bring back our wealthy parents analogy. It's like if the wealthy parents co-signed the apartment lease and then tried to get out of paying the massive damages because you, the landlord, let the teenager paint the living room walls a different color.
Yes, the parents say, that's not the apartment we guaranteed. It was white, not blue.
That is a perfect way to look at it. And a well-drafted PCG explicitly says, no, you are still paying the rent, regardless of the paint.
That's amazing.
Our template contains a masterclass provision in risk allocation, a waiver of defenses. It explicitly states that the guarantee remains in full, robust force, notwithstanding any amendment, alteration, or variation to the contract.
Clause 3.5, I think?
That's the one. It covers any extension of time, any failure or defect in the obligations, and crucially, it even covers the fraud of the contractor.
Wait, even fraud? So if the SPV executives literally commit corporate fraud and embezzle the project funds, the parent company is still financially responsible to the project manager to finish the job.
Yes. That specific waiver ensures that all the usual legal tricks and common law defenses a guarantor might try to use in a drawn-out litigation process to escape liability are expressly negated from day one. They stay on the hook, period. Okay, so you have this ironclad document. The subsidiary goes under, the parent company tries to wiggle out, but your waiver of defenses keeps them on the hook. But securing a promise of funds is only half the battle, right?
It is.
Because as a project manager, you don't just want a massive check in 3 years after an arbitration. You want the facility finished, functioning, and producing clean water right now. How do you actually enforce this document to ensure the project itself gets completed?
This brings us back to the unique nature of Yellow Book projects that we discussed at the beginning. Remember, the contractor didn't just build this facility, they designed it.
Right.
That means there is highly specialized, bespoke engineering expertise involved. We're talking about proprietary chemical processes, specialized engineering software tools, deeply complex structural knowledge. And where does all that crucial knowledge usually sit?
It sits at the parent company level. The SPV is just a shell. They don't own the intellectual property.
Exactly. So the PCG isn't just about extracting financial compensation. It is absolutely vital for what we call design continuity.
Okay, design continuity.
The PCG gives you the legal leverage to force the parent company to step in and provide that technical assistance, to hand over the proprietary design documentation, and to supply the engineering know-how so that you, or a completely new replacement contractor that you hire, can actually finish building the complex facility.
So practically speaking, what is the mechanism? What are the actual administrative steps? Because as we established with secondary liability, you can't just wave the PCG in the air and expect blueprints and money to rain from the sky.
No, you definitely can't. It requires meticulous, almost obsessive contract administration on your part. Before you ever officially call on the PCG, you must formally notify the contractor of their default.
Right.
Crucially, you have to give them whatever cure period is required by the underlying FIDI contract to try and fix the mistake.
And why does that cure period matter so much? What if I just skip it because they are obviously bankrupt, they can't fix it?
If you skip the cure period, you have just breached the contract yourself.
Oh, wow.
And the parent company's lawyers will immediately use your procedural breach to invalidate your claim on the PCG. You have to follow the steps perfectly. You give the notice, you weed the cure period, and then if they fail, you issue a formal notice of termination in strict compliance with the SID's formalities.
So what does this all mean for the listener? It means that keeping contemporaneous records, the daily site logs, the emails, the meeting minutes, isn't just annoying administrative paperwork.
Definitely not.
It is the literal ammunition you need to survive the friction of secondary liability and actually trigger this guarantee. You need documented proof of the program delays, the failed structural tests, the site records. You have to definitively quantify your financial loss with airtight supporting documentation.
Because without that bulletproof documentation, the parent company will simply reject your demand and tie you up in court. But if you do have the documentation and you followed the steps, the template we're looking at makes the actual payout process incredibly brutal for the guarantor. There's a specific provision, a 10-day rule.
Yes, I saw that in the template and my jaw dropped. It says the guarantor must pay the demanded sum within 10 days from the receipt of the written demand. 10 days for a potentially multi-million-dollar payout.
Fast.
And it explicitly states it has to be paid in the original currency the payments were expressed to be payable in, entirely free and clear of all tax deductions or arbitrary withholdings.
It gives them absolutely no breathing room. And if they decide to stall and drag you into a legal fight anyway, The template includes a clause stating that the guarantor bears all legal costs and expenses you incur in recovering those sums.
That is an immense amount of powerful leverage. But even with all this leverage, our legal guide warns about a massive timeline trap that catches a lot of project managers off guard.
Ah, yes.
It involves something called the defects notification period, or the DNP.
This is a major, major pitfall. Under a Yellow Book contract, once the plant is built and passes its initial tests, you issue a taking over certificate. But the contractor's job isn't done.
Not by a long shot.
Right. The DNP starts, and this period can last a year or even 2 years after taking over. During this entire time, the contractor is legally obligated to return to the site and fix any latent defects that pop up.
Right, and for complex process plants like a billion-dollar desalination facility, a structural flaw or a chemical processing defect might not even show up until the facility has been running at 100% full load for 6 or 8 months.
Exactly. So think about the disaster scenario. What happens if you, the project manager, allow the parent company guarantee to legally expire on the exact date of the taking over certificate?
Oh, no.
You take the keys, the PCG expires, and 8 months later, a massive proprietary pump system completely fails.
Oh.
The SPV contractor has long since run out of money and packed up. You turn to the parent company, and they say, sorry, our guarantee expired 8 months ago.
So you have absolutely no protection when those complex, expensive defects finally emerge. That is terrifying. So the PCG must expressly state that it survives well beyond the initial handover. It needs to remain active through the entire DNP, terminating only when the final ultimate performance certificate is issued, proving the plant works perfectly long-term.
That's right.
That is such a critical detail. Never let the safety net drop before the acrobats are actually off the stage and safely in the dressing room.
Precisely. And there is one more critical prerequisite from the guide that we absolutely have to emphasize, because it is where a lot of this careful drafting falls apart in the real world.
Okay, what is it?
It's about who actually signs the PCG in the first place.
You mean making sure it's the right company within the corporate family?
Yes, you must, without exception, identify the ultimate parent company. Often, a massive global corporate structure has multiple confusing layers of holding companies.
Right, like an onion.
Exactly.
Yeah.
If you negotiate this ironclad PCG, but you get it signed by an intermediate holding company sitting somewhere in the middle of their org chart, and that intermediate company is just another shell entity with no actual hard assets, you have defeated the entire purpose of the exercise. You've just traded one empty shell for a slightly larger empty shell.
So how do you practically verify that? How do you know you've hit the top of the corporate ladder?
You demand transparency. You demand to see their audited financial accounts and their official corporate structure charts before you ever accept the guarantee and sign the underlying contract. You have to ensure you are tying your heavy anchor to the solid, capitalized bedrock of the ultimate corporate parent, not just a floating piece of driftwood in the middle of their complicated organizational chart.
This has been incredibly illuminating. Let's summarize the key takeaways. If you are a new project manager taking the helm on a massive Yellow Book project, consider this knowledge your newfound superpower.
I agree.
You now know not to trust the glossy brochure of the SPV structure blindly. You know you have to demand a coextensive, uncapped PCG from the ultimate parent company. You know to ensure the drafting explicitly waives insolvency and common law variation defenses, and you know you must keep that safety net active through the entire multi-year defects notification period.
It's all about one thing, really: converting abstract, implicit financial strength into a direct, legally enforceable, inescapable obligation.
Well said. But before we go, the sources mentioned something that really got me thinking, and it's a perfect thought to leave our listeners with. Our real-world template mentions resolving any disputes over this guarantee through international arbitration. And the legal guide mentions the New York Convention, which is this powerful international treaty that allows you to enforce these arbitral awards in over 165 different countries.
It is widely considered the gold standard for international dispute resolution in construction. It gives the document its teeth globally.
On paper, it sounds incredibly secure, but imagine this real-world scenario. You did everything right. You found the ultimate parent company. But what happens when that ultimate parent company is located in a geopolitical jurisdiction that suddenly faces sweeping international sanctions?
Ah.
Or a country whose government simply decides to refuse to recognize the International Arbitration Award for domestic political reasons? You might have an ironclad, perfectly drafted, beautifully negotiated PCG sitting safely in your desk drawer, but how much does international diplomacy and border politics ultimately dictate the true final security of your construction contract?
This raises an important question, and it really is the ultimate invisible risk, isn't it? It is the exact point where standard contract law ends and the unpredictable chaos of global geopolitics begins.
It is definitely something to mull over the next time you are sitting in a boardroom reviewing a billion-dollar bid from a foreign contractor. Thank you so much for joining us on this deep dive into the world of parent company guarantees. Keep questioning the fine print, keep looking for the ultimate parent, and we will see you next time.
If you're interested in the templates, please visit our shop, the link is in the description.
Thanks for watching. Please subscribe and see next time.